I'm going to talk today about Commanding Officer's summary hearing, and for the purposes of this video I'm going to make an assumption that there has been an interview by the Royal Military Police. There's been an investigation. The Royal Military Police investigation has concluded, and at the end of that investigation the Royal Military Police have decided to refer the matter to the Commanding Officer or the Director of Service Prosecution for prosecution. So the question then becomes, what should a member of the services do once they have been informed that their matter is going to go in front of their CO? The first thing to do is to bear in mind that when the matter goes in front of the Commanding Officer, the service person has a choice. They can either have the matter heard in a summary hearing or they can elect court-martial, and I have provided previous videos looking at the choices, the advantages and disadvantages of taking a matter to court-martial or taking a matter through the summary hearing. In this video I'm going to concentrate on what should happen before that decision is made. The rule is that a service person should have at least 24 hours in order to prepare to go in front of their Commanding Officer for summary hearing. At least 24 hours. Now, the rule of thumb is that the more serious the allegation, the longer the service person should have to prepare. So for the purpose of this interview, I'll take a fairly common example, which would be one of Section 39 common assault, an allegation where a service person has assaulted either another service person or a member of their family or something of that nature. Okay? Such matters might, in some circumstances, go to court-martial automatically, but perhaps more often they will be expected to go in front of the Commanding Officer for summary hearing. The rule is that the service person should have at least 24 hours in order to read through any prosecution papers, discuss the matter with their assisting officer, read through the rights of the accused, instruct a lawyer or consult a lawyer if necessary, approach any defence witnesses if necessary, and that is a lot to ask of a service person within 24 hours. So in some circumstances, and I don't intend to repeat the previous videos that I have made, but in some circumstances it may be appropriate to elect court-martial simply because there's insufficient time before going in front of the CO for summary hearing, although of course it would be possible to ask your CO for more time if it was unfair for you to be expected to trace witnesses in advance of a summary hearing if you only had 24 hours notice. In some cases then it would be appropriate to go in front of a Commanding Officer to agree to the Commanding Officer's jurisdiction. Those examples might be, for example, if a service person agreed that the allegation was true. That would be an example where it might be appropriate to keep any sanction, any punishment at the lowest level and keep it with the Commanding Officer. But there might also be examples where the investigation hasn't been perhaps as thorough as might be expected. For example, if not all the witnesses were spoken to, or if witness statements hadn't been taken from everybody, then in those circumstances it might be appropriate to elect court-martial because it allows lawyers to look at the evidence and to challenge the military police investigation. The difficulty with going in front of a Commanding Officer for summary hearing is that it's quick. It can be too quick. It can be that there is insufficient legal process. And of course remember, when going in front of a summary hearing, if a serviceman is convicted, then that will be a criminal record. Just because it's been in front of the CO doesn't mean it won't go on the police national computer, the criminal records bureau, matters of that nature, and that could have serious implications. So as a rule, if in doubt, it might be best to consider electing court-martial.